Okay, you're recording now, so click through it and you're good to go.
Is it like towards Dam or like oh, okay. I know where I've never been. Like, I know where they're at. Yeah. So will you stay out there or no? We're gonna stay. Yeah. So you won't see each other then until right, walk down whatever. Yeah, I don't know if it's another half. Yeah. And do you regret it? Wow. Such a well, I had to. So I went to the like one. And I also remember trying my dress. Even though it was fixed, it actually looks decent enough. I'm like, that's yeah. And it's not like me or I needed a mature, but there's like this fine line of yeah. I also found that 20 not always, because they were like flashy and like every diamond, every yeah, exactly. But okay, but you know what I went in. Yeah. Like mine, although mine was flowers on it. Yeah. Did not have any cooling on it, which I wasn't aiming. I had well, I remember you had the yeah, so the best part about that was I'm like, well, if I'm getting this dress, I'm really going to spend a lot of money on it. Yes, because I want to leave it here and then I could like a necklace you can wear. I would never wear that. Right. Although having said that, I've never worn that. Like it's quite spectacular. Oh, okay. Yeah. Okay, I'm gonna get you going so people will okay. Okay, if I could have everybody's attention, please, we can get started. My name is Tiffany Paulson. I am a member of the Board of Directors for SUMA. I'm one of the Saskatoon representatives. I'd like to welcome everybody here today. It's great to see so many people here to get the convention jump-started and kicked off. So it's nice to see people here and eager to learn and bring some information back to their home communities. I'll just let you know that this session is being audio recorded, and so when people, there is a Q&A session at the end, so if you do want to ask a question, please come to the microphone. I know you may feel a little bit shy about doing that, but because the session is being audio recorded, we can't record properly unless people are speaking into the microphone. This is something new. I'm supposed to remind you to check page 41 of your handbook to note the emergency exits to the building. I'll just let you know that. So today we are in privacy legislation and counsel. So as some of us are aware, information is often released on a need-to-know basis, but the question is who needs to know and who needs to know what. Councils regularly deal or handle information that could be considered private, and they must make decisions about how and when to allow that information to become public. And so this session is going to walk you through some of the privacy legislation that applies to municipal governments and how to avoid inadvertently breaching privacy laws. We are very lucky, actually, to have Candice Grant here today. For those of you who know me, in my other life, I am a partner at Robertson Stromberg in Saskatoon, and Candice is actually an associate lawyer at Robertson Stromberg and probably one of our more brilliant lawyers. So we are actually very lucky to have her here today because I know she will have a lot of good information and practical knowledge for all of you. Candice's practice focuses on civil litigation, and she has experience in commercial disputes, municipal law, employment law, and education law. Before studying law at the University of Saskatchewan, Candice's studies focused on criminology, and she has a Bachelor of Arts with great distinction in 2005, and her Bachelor of Laws with distinction in 2008. Candice is a member of both the Canadian Bar Association and Saskatoon Bar Association, and enjoys the opportunity to learn new areas of law and develop expertise in how best to provide practical solutions to her clients. So I'd like you all to welcome Candice to the podium, and we'll listen to her presentation.
Well, thank you, Tiffany, and welcome everyone to the first session of this afternoon. It's very encouraging to see such a full house here, so I certainly hope I have some information to offer you that you find helpful. And as Tiffany mentioned, we are recording today, so if you have any questions, I would ask that you keep them to the end, just so we can keep the flow of things going and make sure people aren't trying to get up to the microphone while I'm trying to speak. That said, I do hope we have a fair bit of time for questions at the end of today's session, so I'm hoping that some interesting dialogue comes out of that. So as Tiffany mentioned, the title of today's presentation is Privacy Legislation and Counsel. I'm an associate lawyer with Robertson Stromberg, and one of my main focuses is on municipal law. So there are basically 5 pieces of privacy legislation that can apply in Saskatchewan. We're going to focus on one of those areas today, but I do want you to be aware that there are 4 others that can potentially impact your conduct as a municipal official. The first of those is the Freedom of Information and Protection of Privacy Act. This is a piece of provincial legislation. It applies primarily to the provincial government and to provincial government institutions, so the various ministries and departments. Typically, you won't be having a lot to do with that unless you are corresponding with one of those departments and that department receives a request for the information that you've provided. The second piece is the Health Information and Protection of Privacy Act. This is also a provincial act, and it deals exclusively with health information. So if you are conducting a medical clinic or have a social services outreach department or something like that, this may be applicable to you, but it is not typically something that's engaged in strict municipal law. In addition to those 2, there are 2 pieces of federal legislation that you should, at a minimum, be aware of. First is the Privacy Act of Canada. That applies to the Government of Canada and its federal government institutions. So again, unless you're corresponding with a department of the federal government, it's not terribly likely that that act's going to apply to you. And the second is the Personal Information Protection and Electronic Documents Act. Try saying that one 5 times fast. This one applies to federal business organizations and also to business corporations when they're collecting customer data. But our big topic today is the Local Authority Freedom of Information and Protection of Privacy Act. So this was introduced in 1990-91, and it is a provincial act, and it covers pretty much all of the privacy and freedom of information issues that you're going to come across as a municipality. So for today's purposes, I will either be referring to that as the Act or as LAFOIP. It's not the most beautiful acronym, but it does give us some way to describe the Act. So LAFOIP has two major focuses. The first is protection of privacy, and the second is freedom of information. Sometimes these two focuses seem to be at odds with one another. On one hand, you're protecting personal information, and on the other hand, you're disclosing information to the public. So the one purpose of the Act is to reconcile those two conflicting pieces of, those two conflicting goals, and to provide you with the practical tools that you need to decide what needs to be disclosed and what needs to be withheld. So under the protection of privacy goal, the things that they're looking at there are the collection, use, and disclosure of personal information, and access to files that contain that personal information. On the freedom of information side of things, what we're looking at is public access to information, and the primary purpose there is local authority transparency, ensuring that the local authority is accountable and that its documents are accessible to the public. So before we get into those two areas, which we'll look at in some detail, we're just going to look at some of the basic issues under LAFOIP and how they're going to apply to you in your daily work as a municipality. So LAFOIP, by default, applies to all Saskatchewan municipalities, cities, towns, villages, rural municipalities, northern municipalities. You're all included here. So you're all very much in the same boat when it comes to dealing with these. It applies to all records. Under the Act, a record is a record of information in any form, including any information that is written, photographed, recorded, or stored in any manner. So this extends to emails, correspondence, handwritten notes, photographs. Basically anything you can think of that can be filed is considered a record under this Act. It does not include computer programs or mechanisms for producing or storing the information. And it applies to all records that are under the possession or control of the local authority. So possession, when we're talking possession, typically means physical custody of the record. Is the record physically housed within the municipal offices? And when we're talking about control, we're talking about authority to obtain that record. So this typically comes up when we're talking about, say, third-party contractors, potentially council emails that are sent from home. If the local authority has the right to demand access to that document, it can be caught under this Act. So as I mentioned, the first area that we're going to look at in detail here is the protection of privacy. This starts at Part 4 of the Act, and it includes all personal information. So as you'll see on the slide there's quite a list of items that can be considered personal information. Things like identifying characteristics, race, sex, family status, marital status, sexual orientation, all of those sort of very inherently personal characteristics are going to be caught. In addition, the education, criminal and employment history of an individual, that person's health information or health history, any identifying number or symbol that's given to a person, for instance, an employee number will be confidential. The home, business address, and telephone number of the individual. This one's a little bit interesting. The personal views of an individual, except where they are about another individual, and the personal views of another person about the individual. So that one can take a little bit of analysis to find out whether you fall under it. The one place where I'm finding this one coming up more and more is just in correspondence that does not relate to the workplace, but that is sent through workplace devices. So if you're emailing your mother from your work computer about how you're feeling about your brother's latest job loss, that is personal information. It's not something that's going to be caught under the Act. So other information that would be considered personal information, correspondence that's sent to the local authority in confidence, tax information, financial information, and in some cases, the name of the individual. Now, the name is a particularly tricky one. In some cases, it's considered personal information, and in some cases, it's not. So if you are dealing with an issue of whether you are required to protect the name of an individual, you need to go through the Act in detail, and if that doesn't give you your answer, we suggest you call your lawyers, because it is a very, very tricky, convoluted issue, and we can talk about that a little bit more later on. Now, the other thing to note is that this list is not exhaustive. This is the items that are included in personal information, which means there could be others that aren't specifically listed here. One of the examples of that would be the likeness of someone, a photograph of their face. If you release that, potentially you have released their personal information, depending on the circumstances. So the way the Act works for most things, it'll set out a category of items, like a category of personal information, and then it will set out all the exemptions to that category. So in this case, the exemptions to personal information, there's a few things that are included here. The classification, salary, discretionary benefits, and employment responsibilities of an employee or officer of the municipality or a former employee or officer of the municipality. So you are not precluded as a municipality from disclosing the employment details of your current employees or your previous employees. Personal views which are given by an employee in the course of employment. So going back to my previous example, if your email to your mother about your brother's lost job is about his lost job with the municipality, you're potentially caught. It's a very different issue if it's something that's coming out in the course of your employment than if it's just a personal view that you're giving about something that's not related to your work. And finally, the expenses incurred as an employee while traveling on behalf of the local authority. So, for example, if you're being paid to be here today for your travel expenses, if someone were to submit a request to receive that information, they would very likely be entitled to do so. So just in sort of analyzing those exemptions and comparing them to the list of personal information that is typically required to be kept private, it seems that the main focus here is in keeping the municipality accountable to its public and ensuring that there is a certain level of financial and other transparency, I'm having trouble with that word today, which makes sure that the public knows what's going on within the municipality. So the first aspect that's regulated as far as personal information goes for a municipality is the collection of that information. So certainly in your everyday work, you're going to have some need to collect personal information about your employees, about your council members, and about your taxpayers. It's just unavoidable. That's your purpose as a municipality, in some cases, to have that information and to maintain that information. So the general rule that LAFOIP sets out in terms of that is that it should not be collected unless it's required for a program or activity. And that can be a program or activity that's currently in place or one that's anticipated, but it does need to be related directly to the municipality's functions. Whenever possible, that information should be collected directly from the source. So for instance, when you're gathering information from your employees, you should make sure you speak with your employees directly. If you're getting payroll information, that should come from the employee, not from their spouse or their supervisor or someone else. The individual should be informed of the reason for collection. So you need to narrow your scope here. You need to make sure that you're only asking for information that is relevant to your purposes and that the person has been advised of the reason for the collection. So if you're collecting information about your employees for payroll deductions, they need to be informed. This is the payroll form you need to fill out. We require it to comply with the following payroll regulation. And finally, the municipality needs to ensure that its records are as accurate and complete as reasonably possible. No one's going to hold you to a standard of perfection here. The key here is reasonable. So part of this goes back to making sure you get the information from the source. If you're receiving that information directly from the people to whom it relates, it's very likely that that information is going to be accurate. As we'll see later on, there is a right for individuals to access their records and potentially to request a right of correction. And you need to take that right seriously. Make sure that you are correcting when needs to be correct and periodically reviewing and refreshing your information to make sure that it's kept up to date. So the second category is the use of personal information. As we saw at the beginning, LAFOIP looks to regulate the collection, use, and disclosure of personal information. So the second aspect is the use of that information. And when we talk about use, we're talking about internal use by the municipality. So typically, personal information cannot be used unless you have the consent of the person to whom it relates, unless there's a very limited circumstance that applies. That said, personal information can always be used for the purpose for which it was collected. So if you're collecting that tax information, you can carry out your functions related to taxation based on that personal information. You can't turn around and use it for lobbying purposes or bill collections or something like that unless it falls under one of these very specific exemptions in the Act. So the specific exemptions are set out at Section 28, Sub 2 of the Act, if you're following along. And some of the more significant exemptions include compliance with a rule, a court order, rule of law, or lawful investigation. So if you've been involved in any litigation at all, you may know there's typically an obligation on you to disclose all relevant documents that are in your possession that relate to the matters in issue. So if you have personal information which falls under one of those disclosure obligations, you will typically be justified in disclosing that information, notwithstanding your obligations under the Act. In addition, if there's, say, an investigation going on by a law enforcement agency, you will typically be justified in using the personal information in your possession to comply with requests under that investigation. Second is to obtain legal advice for the municipality. So you are justified typically in using the personal information to make sure that you're legally sound. You can disclose it to your lawyers, but you cannot use it for any purpose outside of that. In some cases, information can be released for statistical purposes. This is kind of a funny one, and you actually have to get a written undertaking from the person that you disclose it to that they won't disclose it to anyone else. They have to prove that the information they need has to be the specific information, that it can't be released in, say, an aggregate or a summary form that wouldn't identify the individual. I don't know really offhand any examples where this might apply. I think it would be a very difficult exemption to establish, and I would recommend that you speak with your lawyer if you're thinking of disclosing personal information for statistical purposes. I think it's going to be an uphill battle to make. And finally, personal information can be used by a municipality to protect the health and safety of any person, or in compassionate circumstances to notify next of kin in the event of an illness, accident, or death. One final exemption, personal information can be used if the information is already publicly available. So if it's something that's on a website, something that's in a telephone directory, for instance, the name and address of someone, if that information already appears in a directory, that can be disclosed. And finally, there's sort of a catch-all that allows the municipality to make disclosure in two circumstances. First, if the public interest in the disclosure clearly outweighs any invasion of privacy, and second, if the disclosure would clearly benefit the individual to whom the information relates. So one example that I've put of this in my paper is basically if a municipal employee went missing and the municipality has the last known photograph of that person. Typically they may be restricted from disclosing that information because it is personal information about an identifiable individual. But in this case, first of all, the individual can't be located to give consent, and second, it's clearly in their best interest that they be found, or in the public interest that they be found. So the disclosure in those circumstances would be warranted. So the third aspect to personal information is disclosure. And disclosure refers to giving the information in your possession to someone else, a third party, an individual, a group, could be just about anybody. So again, unless a specific exemption applies, personal information can't be disclosed without consent. So you're probably seeing a bit of a running theme here. Unless a specific exemption applies, you always need consent to disclose information. Exemptions for disclosure are typically the same as those for use. So as we went through in the last couple of slides, compliance with the law, obtaining legal advice, health and safety, statistical purposes, those sorts of things. Those are when you can also disclose the information in addition to using it. In addition, personal information can be disclosed to the Privacy Commissioner. So this is very standard. If there is a review of a disclosure decision, the Commissioner will ask for a copy of any records that are responsive, and you are required to give that copy. You cannot decline to do so. There's a few municipalities that I think have gotten in a little bit of trouble over this lately. The Commissioner has the right to demand a copy of the document, and you are required to give it. That said, our recommendation is extreme caution if you are disclosing personal information to a third party. It's kind of a minefield for municipalities, and I think you have to be very, very careful because you are trusted with that confidential information to make sure that you maintain that confidence and that the information is only used for purposes that are consistent both with your duty as a municipality and with your duties under LAFOIP. So one sort of unique aspect of this is the personal information of a deceased person. I don't know if this is actually coming up a lot, but the Act does provide for some specific provisions for requests that relate to people who have passed on. So the general rule is that that information cannot be disclosed until the person has been dead for 25 years. At that point, the information can be disclosed to anybody. So sometimes we're seeing this for archival, genetic research type purposes. It's a little bit unusual. The other place where we might see this is related to estate administration. And the Act has a specific exemption that if the personal representative of a deceased person is requesting the information to administer their estate, then they can receive that information. So there was actually a fairly recent decision from the Privacy Commissioner that spoke about this particular issue. It was a woman who had received some care from a local health authority. The family was not satisfied with her care and she ultimately passed away. So the son, who was actually not the estate administrator, requested personal information from the hospital as to what sort of care she'd received in her final days. Now, the commissioner first held that he was the personal representative because he had explicit authority from the estate administrator, and then second held that that information should be disclosed because he was seeking to see whether he had a lawsuit, a potential cause of action against the local health authority. And in that inquiry was apparently administering the estate. So what we can take from that decision is that this exemption will be construed pretty broadly. The other exemption under here is that if the disclosure to the next of kin is not an unreasonable invasion of privacy, it should be released. And so my suggestion to you would be to read those two exemptions together. So in most cases, if you're dealing with a personal representative, if that person is also the next of kin, unless there is a very compelling reason to hold the information back, it should typically be disclosed to the estate administrator. But you always use your discretion and keep in mind that it is still saying if there's not an unreasonable invasion of privacy. So it will be in your discretion to determine whether disclosing the information relating to that deceased person is an unreasonable invasion of their privacy. So one issue that comes up fairly frequently is an individual's right to review their own file. So this could be a ratepayer in your municipality, it could be an employee who wants to look at their personnel file. There's numerous circumstances where this might come up. And the basic answer here is that typically an individual has the right to review any documents or records that contain their personal information. Now the process for that, there's a formal application form that they need to fill out, and then they need to prove that they are who they say they are. Now, I'm sure a lot of you are thinking, well, I know who my employees are, I don't need them to prove that. We would suggest that out of an abundance of caution, you always go that extra step and get the proof that they are who they say they are. The main reason for this is because the request has to be submitted in writing in the prescribed form. So you might get the form and not receive it directly from the individual to whom it relates, right? They might leave it on your desk to deal with within the next few days. So unless you're receiving the form directly from the person who's making the request, my suggestion is that you always get that piece of information that confirms that they are who they say they are. This could be a driver's license, passport, birth certificate, all those standard pieces of identification, but I think you do need to make sure that you're dealing with who you think you're dealing with, or you're potentially opening yourself up to a complaint that you've disclosed personal information to someone that you shouldn't have. Now, there are a couple of exemptions to the right to access one's personal file as well. So the first of those relates to records which are evaluative or opinion material, basically to determine if someone is suitable for an employment position. So this would typically come up in the job interview type situation. If you're interviewing a candidate, you made some notes as to whether they're suited for the position or not, and then they later make an application to receive that information, you can hold that back. You are not required to disclose that. It is a discretionary exemption, so you do have the discretion to decide whether to hold it back or to disclose it to the applicant. So certainly you're making a judgment call there about whether you want to provide that person with the information, particularly if they were not the successful candidate, but you do have that right to make that decision. Now, the second exemption to the right to view relates to other individuals and their personal information. So if the record that access is being sought to has the personal information of a third party, that information cannot be disclosed without their consent. So you may be looking at either trying to obtain the consent of the other person who's referenced in the document or severing those portions of the record out. Now that exemption is mandatory, so you do not have the right to disclose that third-party information unless it falls under an exemption or you have consent. So an example of this one might be a workplace incident report or a harassment investigation report, something of that nature, where the individual is seeking access to their own personal file, but also to the findings or conclusions about another party. And in that case, you would have to be very careful to make sure that you're not making an inappropriate disclosure. Now, the final aspect to the right to view is the right to request a correction. Now, this relates back to your obligation as a municipality to ensure that your records are as reasonably correct as possible. So if an employee or any individual does happen to access their record to note that something in there is not correct, at least in their view, they have the right to request a correction of that record. Now, this doesn't necessarily mean you have to correct it. Particularly if you're talking about something like a harassment investigation report, a workplace incident, a disciplinary letter, anything like that, it's quite likely that the person disagrees with your conclusions, and you are not required to correct that. You are required to make a notation on the file that the person requested a correction and that it was done or not done. So that basically wraps up our section on personal information. And we'll move into the access to information portion. So as I mentioned, this is the second focus of the Act, which is making sure that the public has access to information that is in the possession or control of the municipality. So some basic principles under this portion of the Act. I will say in my experience, most of the problems that I've seen which have arisen for municipalities relate to this portion of the Act. These information requests are difficult to deal with. There's very strict timelines in the Act, and a lot of people just aren't aware of what their obligations are. A lot of times it's an issue of lack of resources. You're very busy, I'm sure, in your daily lives. You don't necessarily have the time or the staff to be devoting towards these requests. So this is definitely the area where we're seeing the most difficulties for a municipality. Now, under LAFOIP, the head of the local authority has most of the obligations under the Act. So when I speak of the municipality, what I really mean is the head of the municipality. And by default, the head of the municipality will be the reeve or the mayor. Now that person probably isn't in the office as much as some of the administrative staff, maybe doesn't have the resources or the time to devote to doing these types of issues, probably has a second job, all those concerns. So often the head will delegate his or her authority to someone else who is a little bit better positioned to deal with these requests on a day-to-day basis. Now that is under Section 50 of the Act, and it provides that the head can delegate his or her authority to any other person that they see fit, and that delegation can be subject to whatever limitations the head deems necessary in the circumstances. And now typically I have seen just unequivocal delegations. The mayor will say, I appoint my administrator to deal with any issues arising out of LAFOIP, and this will remain effective until I revoke it in writing. That's sort of the basic delegation that we're seeing. There's no specific magic wording to it. It just needs to be in writing and to confirm the delegation to a specific individual. But certainly the person would be entitled to put any limitations they want to on that. So for instance, if you're dealing with someone who's maybe new to the position of administrator, doesn't have a lot of experience in it, hasn't had any training in LAFOIP yet, it might be appropriate to say, I delegate my authority under LAFOIP to the administrator, subject to the limitation that he or she cannot make a decision to deny a freedom of information request without checking with me, something to that effect. So it's important to remember that although the head has delegated that responsibility, he or she is still ultimately responsible to supervise it. So care should be taken in doing your delegations. Make sure you're delegating to someone who is competent and who's going to take the time to really consider the issues under the Act and make sure they are making a compliant response. So a person who receives the delegation typically becomes a privacy officer for the local authority, and they will then handle the day-to-day requests that come in on this topic. So the basic concept on this half of LAFOIP is the presumption of public access. The idea under the Act is that the public is entitled to as much information as possible. And so on this side of the Act, information has to be disclosed unless there's an exemption. So if we contrast that with the personal information side, where information must be kept private unless there's an exemption, this is the complete opposite of that. Unless you're relying on a specific exemption in the Act, information always must be disclosed. So first thing to note under the freedom of information end of things, record storage and retrieval. As you'll have seen before, the definition of a record is very broad. We're talking notes from meetings, emails, correspondence, reports, recordings, photographs, everything. So if it can be filed, it will be considered a record, and it's your duty as a municipality to make sure that your files are in a manner that can be searched easily and that the files can be retrieved. Many freedom of information requests we're seeing are extremely broad. They will request all correspondence between a municipality and a third party for a period of 5 years. And you need to be able to call those documents up with a minimal effort. Because of this, it is imperative for you to have a good system of access and retrieval, and ideally to have some staff who's familiar with that access and retrieval to be able to facilitate these requests. If you get to the stage where you're looking at charging an applicant for information or for the access to information request, you can only charge them for seeking information in well-organized files. If you say, well, our files are a mess, it's going to take us 3 hours to even get to what you want, the commissioner is going to look at that and say, that's your problem. The applicant only has to pay you for searching within organized, efficient records. So sort of getting to the heart of the freedom of information side of things, we're talking about requests for information. So a request for information can be submitted by any individual. They are not required to disclose to you why they are seeking the information or if they are working on behalf of another entity or group of individuals. It can be just about anything. Now, organizations themselves cannot submit information requests, so it is quite typical that you will get a personal information request that you can pretty easily trace back to the source. I know I have occasionally done these on behalf of clients under my own name, and if someone were to Google my name, it's pretty obvious that I would be working for someone else there. So it's usually easy to trace back where these requests are coming from, but they're not required to disclose that, and you cannot respond differently to the request based on who you think it's being initiated by. So the request should typically be submitted in the prescribed form. I'm sure you're all very familiar with it. There is actually a decision from the commissioner as well, though, that says even if they fail to submit the correct form, if it's clear from the material you do receive that it's a freedom of information request, you should proceed just like you had received a proper form. The commissioner will not deny an application based on a technicality like failing to submit the right form. A request has to be has to be accompanied by the fee of $20, pretty straightforward. And the applicant is required to identify the records that he or she is requesting. So the onus at this stage is on the applicant to allow you as a municipality to determine with sufficient clarity what records you're looking for. So that only applies, though, to someone who is sufficiently familiar with the files. So again, going on a wild goose chase, digging through a bunch of unorganized documents is not going to be enough here, but you are entitled to say, based on the information we've received, we have no idea what you're looking for. We need better information. And if that happens, you are more than entitled to go back to the applicant and request better information. All right, so the implied duty to assist. This may come as a bit of a surprise. Under the Health Information Protection and Privacy Act, there's a specific section that says that a body receiving a request has a duty to assist an applicant. There's nothing like that in LAFOIP. And notwithstanding that, the commissioner will take the position that as a local authority, you have a duty to assist an applicant in making an application. So their position is that this is implied by the Act and by the general principles of disclosure. So the local authority, in order to meet this duty to assist the applicant, must respond to all requests openly, accurately, and completely. One recommendation we can make on this point is to communicate with your applicants. If you give them a call, discuss the request, say, what are you really after here? You can usually narrow the request down a little bit, and you will be seen as meeting that obligation if it ever comes to the review stage. So communication is really the key here, just making sure that you're constantly trying to provide as much assistance and, if appropriate, as much disclosure as you possibly can to an applicant. So under Section 11 of the Act, in certain circumstances, you can transfer an application. And why wouldn't you want to? Because then you don't have to deal with it. So if the applicant has sent their request to you and you believe that you're not the appropriate authority to be dealing with it, you can, in some circumstances, transfer it on. So the test for that is whether another local authority has a greater interest in the record. And the interesting thing about this is it can happen even if you have a copy of the record. So for instance, maybe a neighboring RM obtained a report on the status of roads in the area, and they provided you with a courtesy copy of that report. If you receive a request for information to access that report, even though you have a copy of it, you would be justified in sending it back to the RM that requisitioned the report. The test for greater interest in the record is whether the other local authority made the record or had it requisitioned, or whether it was the first to obtain a copy of it. So just keep those issues in mind. Recall that you can transfer an application if it's appropriate to do so. Now that doesn't end your obligations. You still have to give notice to the applicant that it's been transferred and to whom it's been transferred. But it can be appropriate in circumstances, in particular where you're dealing with that third-party information, if you don't want to have to be the one who makes the call on whether it gets disclosed or not. Now, if you are on the other end of this, if you receive a request from another municipality or local authority, this basically just starts the process over for you. So you're required to review the request and to respond as set out in LAFOIP. So, speaking of responses required, Section 7 is the key section under the Act. From here on out, I'll refer a couple times to a Section 7 response, and this is basically what we're talking about here. If you only read one section of the Act, read this section, because this is the section that sets out your main obligations in making a response to a Freedom of Information request. Now, unless there's an extension of time, which we'll deal with on a couple slides from now, you have to make that Section 7 response within 30 days. Now, the Commissioner is extremely tough on this and will not look favorably on it if you do not make that response within 30 days. That alone can be enough to initiate a review. So just keep it in mind. Make every effort that you possibly can to make sure you're complying within the timelines. A lot of the timelines in the Act are extremely quick, especially for a smaller organization that maybe doesn't have staff every day, doesn't have council meetings all that often. It's a very tight timeline, so just keep it in mind. Now, the options for your response under Section 7 are either to indicate that access to the record or a part of it will be made on payment of the fees. 2, if the record is published or if it's going to be published within 90 days, to direct the applicant to that publication. 3rd, to indicate that access is refused. If you do so, you must also indicate the reasons for refusal and the specific sections in the Act that you are relying on for your refusal. Or 4th, to state that access is refused because the record doesn't exist. I cannot emphasize enough that these are your only options. You cannot make any decision to grant or deny or anything, any record, if you do not fall under one of these 4 categories. In addition to whatever decision you've made in those 4, which we'll go over in a few minutes, a Section 7 response must indicate that the applicant can request a review of the decision within 1 year. And that goes up to the Privacy Commissioner if they do make that request. A failure to put this line in, again, will be enough to get the Commissioner to review the file. So it is absolutely imperative that you are including this information in all of your correspondence. Our suggestion is that you develop a template that you are sending out to applicants, including this line in there. And it doesn't matter whether you've agreed to provide access, to deny access, to provide partial access, this line always needs to be in there. Now, if you don't put this in there or you don't comply within the 30 days, The commissioner will do what's called an expedited review. And we'll talk about the review procedures a little bit later on, but the expedited review is a little bit different process, and it's basically aimed at getting you to comply with Section 7. So if you haven't provided a response, or if your response is not adequate, the commissioner will first thing require that you provide a compliant Section 7 response. And then at that stage, if the applicant is not satisfied with the response they've gotten, then they would proceed through the regular review process. So the extension of time, basically you can buy yourself another 30 days for response if you meet one of these three criteria here. You have to either claim that the application is for access to a large number of records. So as I said before, someone who's looking for 5 years of correspondence, that's going to take some time to put together. If there are a large number of requests, sometimes people will submit multiple requests, nicely broken down, one document or several, but manageable per request, but they'll submit 10 of them. Or alternatively, if the municipality is required to engage in third-party notices, and we'll talk about that as well. So important to note under this section, those are the only three reasons for requesting an exemption or an extension. The fact that you are short on time or short on staff is not adequate to invoke this section. So if you are going to rely on this, if you do fall under one of those three categories, the first thing you have to do is notify the applicant. And so you can extend up to 30 days. You don't need to use the full 30 days if you don't need it. But in most cases, you're probably going to want to get yourself as much time as you possibly can. And if you do invoke this section, you still have to give a compliant Section 7 response now within the 60 days rather than the 30 days. So your options for response don't change. You've still got those 4 options. And you still have to include the bit about review by the commissioner. You just bought yourself a little bit more time to deal with it. So searching for records. The search has to be really thorough, and that's one thing that we've seen in a few decisions from the commissioner. The person responsible for carrying out the search will search either the computer or the paper folders, but not both. They won't carry out an extensive search that really gives them confidence that they've found every record that's responsive to the request. So you really have to carry out a big request, or pardon me, a big search, unless you've got a narrow request here. If the request is, for example, I want a copy of the report commissioned by XYZ Limited on or about December 2009, you can narrow that pretty well, and you don't have to carry out a big search like that. But if they are saying, I want all correspondence between the mayor and this company from December 2009 to December 2012, you're going to have multiple places where you need to look for that information. Our recommendation is that you take clear notes of any search efforts that you're undertaking. So jot them down, make a computer file, whatever works best for you. Just make sure that it's clearly documented and keep that with the documents that relate to the request. If it goes to a review stage and the commissioner is questioning whether or not you've made adequate search efforts, these are some of the issues that they're going to look at. So did you search records in every form? If the request was really broad, how did you determine which records you were going to search? If the search was delegated, how can you be certain that it was comprehensive? Did you check with all of your other departments? And are there records that might be responsive to this that you have the authority to request that you don't have in your physical possession? If you're not carrying out a search that allows you to answer all of these questions, the commissioner may go back and make you redo portions of your search. So getting into then those 4 options that you have under Section 7 to respond to a request. Your first option is to grant access to the record. So as you'll recall, the section provides that you can make the person pay fees before you do that. If the responsive records are fairly minimal, our suggestion is that you just accept your $20 application fee and provide them with the records. If you're talking a minimal amount, it's usually not worth your time and effort to try to coordinate that. But in general terms, if there's no exemption applicable to a request for information, access has to be granted. And this just goes back to the overarching theme of this portion of the Act, which is information should be disclosed as much as possible. So unless you're pointing to something in the Act that specifically says you do not have to disclose this, you're going to have to disclose it. If an exemption applies to only part of the record, the general principle is that you have to sever that portion and provide access to the rest of it. So if we go back to, for example, the request for personal information about a workplace incident, you would have to sever the records that relate to the other person's personal information and disclose to the applicant the portions that relate only to their personal information. So you're always under a presumption that you're going to disclose as much information as possible, even if that means redacting portions of your records. One interesting little anecdote coming out of this, the commissioner has decided that the to and from lines and the subject line of an email are typically not subject to an exemption. Even if the body of the email is exempt, you will typically be required to provide the information that says who sent the email, who it was sent to, and what it was about. Now, to me, intuitively, that's not a lot of information, and I would probably say that the entire document would be exempt in those cases. It's not. So be sure to make sure you are always disclosing as much information as you can, even if it seems like it's pretty worthless to you. Now, just a quick note on some exemptions. There are mandatory and discretionary exemptions. So a mandatory exemption means you must prevent disclosure of that document. A discretionary exemption gives you the discretion to determine whether you're going to grant disclosure or not. Now, you are required to use good faith in determining those exemptions, and in some cases, you probably will want to grant access, even though the Act says, technically speaking, you can deny it. You are required to use good faith in determining that. So looking at, is the disclosure in the public interest? Is anyone going to be harmed by this disclosure? Is anyone going to get an undue benefit by this disclosure? And if those questions don't lead you to the conclusion that it should be withheld, notwithstanding the exemption, you probably want to disclose that information. So just a quick few notes about fees here. Now, as I mentioned, our standard advice is if it's $10 or less, you're probably just going to grant the disclosure, send a copy of the record with your Section 7 response. But in some cases, you may be entitled to collect additional fees, and you may want to do so. So the most common fees that we're seeing, first of all, is $15 per half hour of searching records or each portion thereof. Now, I like that they've done this on a half-hour basis because I think it's important for you if you're spending a lot of time to recover your fees and to make sure that you're getting some compensation for the additional work that you're doing under this section. Now, the first hour of searching is included in the $20 search fee, or in the $20 application fee. So you only start charging for search fees after that first hour. And then in addition, you're entitled to charge 25 cents a page for photocopying. Now, one of the questions that comes up sometimes is, are you entitled to require payment up front? And if the fees are going to exceed $50, you can require up to half of it be paid beforehand. Now, the question here is whether it's always in your best interest to do that. If you do provide a fee estimate, you can't go back and charge the applicant more than the estimated amount. So you're kind of binding yourself to that estimate. Now, advantage of this, of course, it ensures that you're going to be paid. In particular, if you're talking about a larger amount, at least you're making some recovery before you're providing that disclosure. It can dissuade some applicants if they're on a fishing expedition, if they've requested a very large number of documents. If your fee quote is reasonable but large, it may dissuade them from proceeding any further with the application. The disadvantage, of course, is you do bind yourself to it. So if it turns out taking a lot more time than you're expecting, you're still stuck with it. So just a little bit about preparing your estimates. Again, none of this is in the Act, but the Commissioner will be looking for these particular items if it's ever asked to review one of your fee quotes. So the Commissioner wants to see the estimates broken down into time spent searching electronic records. Typically that should be less, but if you've got a very convoluted file system, a number of searches you need to do, you need to be able to back up your quote. And then a time required to prepare your electronic records. So if it's a retrieval, a printing, those sorts of things, you need an estimate for that. And then in addition, you need an estimate for time spent to search other records and the time to prepare the other records. And then finally, your estimate should include the costs of reproduction. Now, you cannot request time for photocopying. The commission determines that because they're already paying 25 cents a copy, it's subsumed in that. So time to prepare electronic records or time to prepare other records only relates to your time to compile those records, potentially to redact out other information that can't be shared, but it does not relate to your actual time at the photocopier making your copies. The fee estimate also has to indicate how many employees are going to be involved in the search, and if there's more than one employee that's going to be doing it, you need an explanation as to why 2 or more are required. Not to say you can't have 2 or more, you just need to be able to justify that requirement. And your fees must be fair, reasonable, and at a level that does not prevent a reasonable person from exercising those rights. The concern here is that some local authorities have issued very, very large fee quotes on the hopes that it will prevent the person from proceeding with the application. And the commissioner will throw those out, will require a new fee quote that is in compliance with these guidelines and that is reasonable to the amount of information that's being requested. In addition to that, an applicant can request a waiver of fees. There's a couple circumstances where this applies. First, for their personal information, and second, if it's going to be financial hardship and the disclosure is in the public interest. So fairly narrow. The key there is to know that personal information can be subject to a waiver request. It is just a request. You are not necessarily required to grant it, you are just required to consider it. So refusing access. This is where I've seen most municipalities get into trouble. So keep in mind at all times that you cannot refuse access unless you've got a specific exemption in the Act that you're relying on. That's the base information. If you take one thing out of today's presentation, take that. Now, in addition, if you don't make any response within the 30 days, you will be deemed to have denied access to the entire record. This typically means that on review, the record is going to be disclosed, unless there's a mandatory exemption that applies to it. If you failed to cite any exemptions that you're relying on, you will typically be required to produce that record. Now, the Section 7 response that we go back to has to set out the specific exemptions that you are refusing to disclose. The commissioner will not normally consider these if they're raised at a later date. So we've seen a few cases where the local authority will issue a decision saying we're relying on sections 16A and B in our decision not to disclose this record. And when they get to the review stage, they're saying, yes, we rely on sections 16A and B, but also on 18D, F, and so the position of the commissioner has been they will not look at those exemptions that are raised at a second stage unless they relate to a mandatory exemption. So it is, again, our general recommendation, if you don't know what you're doing here, speak with your lawyer before you're going to deny access to something, because this is by far and away the area that we're seeing the most trouble with compliance. So just walking through a few of the exemptions quickly, this is a very lengthy portion of the Act. So when you do get a piece of information that you're determining whether or not to disclose, it can help to have it side by side with the Act and just go through the exemption sections, check off whether any of them apply or not, because I can't even give you in the space of the time we have today a comprehensive overview of the exemptions. There are a lot of them. They are narrowly construed by the commissioner though, so keep that in mind while you're determining which of those might fit with your particular request. But some of the major exemptions, first of all, documents obtained in confidence from another party, and particularly from a government agency. So if you're getting documents from either another local authority or from a provincial or federal government institution, it's likely that those can be withheld pursuant to the Act. If there's documents that might prevent execution of a law enforcement operation, whether it's an investigation, prevention, prosecution, those can also typically be withheld. One of the bigger ones, documents that are internal records of the municipality that have not and will not be made public. So for instance, draft documents, in particular draft bylaws, anything that discloses the contents of your in-camera meetings, advice or analysis or policy options that have been developed by or for the municipality, documents regarding contractual or other negotiations, financial, commercial, scientific, or technical information that belongs to the municipality, legal advice, obviously, and then in addition, testing or auditing procedures if they might interfere with the conduct of that actual testing or auditing. And so then again, we've got another sort of catch-all here, documents the release of which might result in an undue benefit or loss to another person, or which might threaten the health or safety of any person. So most of those are discretionary exemptions, which again means you are required to consider whether it's in the best interest of the municipality and the public to disclose this information, notwithstanding that you might be able to rely on one of these exemptions to withhold that information. These are also the exemptions that the commissioner will not consider if you bring them up at a second stage. So if you're going to rely on one of these, it needs to be done right from the start. The other major exemption is third-party information. So this one is mandatory. If the third party does not consent and one of these exemptions and one of these exemptions applies, the information has to be withheld. So you have no discretion to release this information unless the third party consents or you've got a specific reason to under the Act. So third-party exemption will apply if there's trade secrets of the third party, financial, commercial, scientific, technical, or labor relations information supplied in confidence by the third party. So a lot of times this could relate to, say, responses to requests for proposal. If someone's submitting proprietary drawings to you or something like that, that they're proposing to work on a parcel, that would be subject to that third-party exemption. Financial statement of account relating to a third party with respect to provision of routine services. So if you can't get your neighbor's water bill, sorry. And information, again, the disclosure of which could reasonably be expected to result in a financial loss or gain, prejudice the competitive position, or interfere with contractual or other negotiations. Now that one I would say is probably the most common one that I see cited by municipalities. It must be done with a sufficient amount of particularity. In one particular review that the commissioner did and released a report on, they found it wasn't just sufficient to say it's going to interfere with our contractual negotiations. You have to say what particular contractual negotiations are going to be interfered with. That may be narrowing it as to time or content or parties, but you've got to be very particular on that issue. So the procedure in dealing with a third party, first of all, the third party doesn't actually have to receive notice unless you as a head intend to give access to that information. So if your decision as a municipality is to deny access to the information on a number of other grounds, you don't technically have to notify the third party. In practice, you're going to want to do it all the time because the commissioner is going to ask you as soon as they get a request for review whether the third party's been notified or not. And if they haven't, then the commissioner will undertake notifying the third party, and it typically doesn't reflect all that well on you. So our suggestion is to always notify the third party if you receive a request for information that involves their personal information. The third party also always needs to be asked if they're consenting to the disclosure. Even if your position is that the third party wouldn't want it disclosed, you need to confirm that because that again is something that the privacy commissioner will be asking about if they go to a review stage. In response to that third party notice, the third party can give you representations as to why the information should or should not be released. And you as the head of the municipality get to make the decision as to whether to adhere to those representations and deny access or to grant access because you feel that it's just inappropriate to do so. The notice of that decision must be made to the applicant and to the third party, and then they both got some requests for review. So if you do end up disclosing information which has triggered one of these third party applications, in that case it is important not to provide the record with your decision because they do have, the third party for instance, has the right to say, we're requesting a review by the commissioner because we don't feel your decision was appropriate. Just the note there, this is going back to that issue of disclosing the name of an individual. This is one of the cases where the commissioner has said that it is not appropriate to disclose a name, that is an inappropriate disclosure of personal information. So in your notice to the third party, the person should only be referred to as the applicant. They should never be identified by name. The reason for this, the commissioner advises, is that they don't want the third party making their decision on the basis of who's asking for that information. There was one incident where it was a competitor of a contractor with the city was asking for copies of their contract, and that person was identified, and that ultimately came to be a breach of the obligations for personal information confidentiality on the municipality. So our recommendation there is always to refer to them only as the applicant. So just a few notes on confidentiality. Many of the exemptions relate to information which is supplied by a third party to the municipality, and the standard wording is implicitly or explicitly in confidence. So what does that mean? There's a few indicators that a document will be considered to have been delivered in confidence. Whether the document is marked on its face as confidential, whether it's delivered in a sealed envelope, whether the municipality has provided any specific assurances to the third party that the information is going to be kept confidential, whether it's part of a confidential process. All of those sorts of issues are going to be looked at, and it typically is not enough to say to the commissioner, this was provided implicitly in confidence, unless it's very sensitive subject matter, in which case that might carry some weight. You're going to need to make sure you're following some of these safeguards in determining that the information was supplied confidentially. So you've heard me mention a few times the review by the commissioner. So this is assuming you've gotten through all of the other stages that we've talked about. You've issued your Section 7 response. You've either provided disclosure or not. You may have notified a third party, made a decision on that. Once your tasks are up under that initial phase, that's when the commissioner review starts. Now, one interesting thing to note, I have found that the commissioner is specifically asking applicants whether they want a review. In particular, if you've had a non-compliant Section 7 response to begin with and gone through that expedited review procedure, the commissioner will follow up with the applicant and find out whether they want to escalate it to this stage if they weren't satisfied with what they got previously. So I guess a practical tip, if you go through that expedited review phase, you've probably been red flagged and you're very likely to also end up at this review stage. So in most cases, a review will be instigated by an applicant who's not happy with the nature of the information they've received. Either they've been refused entirely or there's been severance of the record, but in any event, they're not happy. A request for review can also be brought on a fee estimate if the applicant's not satisfied with that, and can also be brought by a third party if they're not happy with the decision on their exemption. Now, the important thing to note at this stage, the commissioner cannot order anyone to do anything. The commissioner only makes a recommendation and puts that in a report, and that becomes public record. It goes to the applicant, it goes to the municipality, and you're required to make a response, but you're not actually required to implement the recommendations of the commissioner if you disagree with them. Now, the commissioner can refuse a request for review if they determine it's frivolous, vexatious, or just in relation to a trivial matter. As far as I know, that's exercised very rarely. Often the commissioner will take these items quite seriously, even if they appear to be trivial on their face. So all parties who are involved in the decision will have a right to make submissions during the review. So typically this would be yourself as a municipality as well as the applicant, but if there's a third party involved, then they're also involved in the review stage. The commissioner will typically require a copy of the record. As we talked about before, this is an exemption to the personal record confidentiality provision, so you are entitled to give a copy of that record. The commissioner will not share the record with the applicant at any point. Now, on completion of the review, the commissioner issues a report that has recommendations, and often those recommendations are whether the particular document should be released, shouldn't be released, whether the exemptions are appropriate, whether the fee estimate's appropriate, all of those sorts of questions. And on receipt of that report, the head has 30 days to make a decision, whether to follow the recommendations or any other decision that the head thinks is appropriate. So basically, even if the commissioner says this document should be released, we don't believe there's any exemptions applicable, you can make the decision as a head. We're sticking by our guns. Section 16A or whatever you're relying on applies, and our decision is not to release the record. Now, if your decision is not to follow the recommendations of the commissioner, there is a potential appeal to the court. This is very rare. I don't know if anyone's been following the media, but there is actually one of these pending right now. And the outgoing privacy commissioner said there's been 2 or 3 in the past 10 years. So it's very rare that anything reaches this stage. I think the reason for that is most local authorities will follow the recommendations of the commissioner, whether it's to release a document or not. And so very few things are getting up to the court. But that said, it is an option to applicants, and they can request a further review if they decide to do that. The court on review has very broad powers, so they can order the release of the document. The commissioner cannot, they can only make a recommendation, but the court can order the release of the document. They can also make any order they think is appropriate. Usually this means costs. So if the court agrees with the commissioner, agrees with the applicant, and disagrees with your position, they can order you to pay costs of the applicant in bringing the application to the court. So that's it for the formal end of the presentation. I'll invite anybody who's got questions to step up to the mic.
I'll just add a couple of notes as Candace finishes her presentation. And just a reminder, remember that the questions have to come to the mic, and maybe just identify yourself and where you're from. And I am glad to see there's some questions, because I had some ready here just in case we didn't see anybody at the mic. I know that was a lot of information for everybody here, and it sounds very complicated and scary, and often people even wonder, is this going to actually apply to me? I can tell you in Saskatoon, which is probably, I realize is a larger centre, this has been a hotbed of controversy in Saskatoon. The Saskatoon administrators, as well as the councillors, all have their email accounts regularly accessed and through FOI requests. And we have learned the harsh consequences of lack of privacy from our perspective. So this is something that is going to trickle down to municipalities, because it's already happening in some of the larger centres. And to put it in practical purposes, Candace had earlier accurately said, with respect to privacy, because we all tend to think of our email accounts as private, that emailing your mom about how you feel about one of your brother's job loss is private. Candace is correct, but as one Saskatoon City Councillor found out, emailing someone about how you feel about your colleagues on council is not private information and will be published if that's found on your email account. So there are some pretty harsh consequences to some of these things. So I will turn it over to some questions, and we'll hear what's on your mind.
Hi.
It's on. We
It's
can
on?
hear.
Okay,
Yes,
good.
thank you.
Just can't tell. I'm the head of Kenaston. Just a couple questions. I don't think we've ever gone through this process or had to, which is good. What I was wondering about, I guess, is a detail with landlords and water bills, which I know is, they're a third party. They own the building, but we're not allowed to let them know if the water bills are in arrears. Is there anything that we can do? Can we bill the landlord direct? I know I'm not the only community that has this issue. Like if you ask the tenant, you know, when they come to hook up their water, do you want your landlord to know, you know, have the information? They're not going to say yes. So what do other centers do? Everybody that I've spoken to, you know, the tenant can be gone before you even realize that they're, you know, haven't paid. And the second question I have is regarding our minutes. We are putting everything on our web, or in the process of, as a lot of small communities are, and large centers. Specifics as to, we have agreements that a lot is purchased and they have a year to build or whatever, but it goes into our minutes directly, the legal and who has signed up for this, like taking out the agreement. Is that a breach of privacy when you put a name behind it on a web? We can't run 2 sets of minutes.
Right. So I'm going to, both excellent questions. I'm going to let Candace start with the answers, and if necessary, I may provide some practical examples too from in Saskatoon who regularly deal with particularly the minutes issues.
Yeah, so on the first question about the water accounts, I think you're absolutely correct. Without consent from the tenant, there's really not a lot you can do to say we're going to disclose this information to the landlord. If the landlord puts something in their rental agreements that provide we can get this information from the city, then that I think amounts to consent and you can disclose it that way. But absent something either directed to the city saying we can provide this information to your landlord, or alternatively in the agreement with the landlord saying that we can obtain this information, the specific provision that says you can't get a routine account for services will apply. Now on the second issue, the minutes, I think there was a similar issue that came up for one of the villages that's in one of the commissioner reports. It was an individual who made a request for information that had all of the names, addresses, telephone numbers, and legal land descriptions for the property owners within a certain development. And the commissioner in that case took the position that because most of that information was already publicly attainable, it was not, first it wasn't on the municipality to provide that information. If you can get it some other way, whether it's through ISC or through a tax certificate, then it's on the applicant to get it that way. But also that disclosing that information wouldn't have been inappropriate because it is already available. So if you're talking about someone who's acquired a lot and has a certain amount of time to build on it, the acquisition of the lot and the legal owner is already public record. So, okay, I'm sorry. Oh, okay. Okay, and these are municipal-owned lots that you're transferring to these developers once that's occurred. Okay. Okay. I'll maybe let Tiffany offer a couple comments on that if she's got some. I don't. Yeah, that's an interesting one.
That's an interesting question because we handle the requirement to build differently in Saskatoon in that we do transfer ownership of land right away, but there is a requirement to build. The city puts some type of lien on the land, and if the land isn't built, then there's a transfer back. And that's a very brief summary of the process. So there's the city, and I agree with Candace, once land has been, the city publicly discloses all land sales to people because that's, easy information. I don't know if, because the city of Saskatoon doesn't follow that same process, I don't know if I would know. We'd have to think about that. I don't know if I know the answer to that offhand.
Well, you have given me the answer. Thank you. It's just you transfer the land, place the lien on it, get a transfer back on file.
And the city's policy, the city of Saskatoon's policy for requirement to build is on our website. So have a look at it and plagiarize away. So. Yes.
David Tran, Mayor of Nipawin. I have a couple questions. At the start of the presentation, it made mention about the Mayor and Reeve, or Reeve had to give authority in writing. Can it be done as a matter of policy, as the council's policy, or under the Municipalities Act, or do we have to have a letter in writing each time that we delegate the authority?
Are you okay if I answer?
That's
so
one
this,
question.
sure. So the city of Saskatoon, good question, and I was actually going to add this as practical advice. Saskatoon City Council designates its head not to be the mayor or the Reeve, and it's an administrator, and we've done that once, and it's an ongoing appointment. It's not for every time, and I would suggest everybody do that. The city used to designate, the city of Saskatoon used to designate their administrator as the head, and that's probably just as easy for some of the smaller communities here. We've, given the huge volume of FOI requests we have at the City of Saskatoon, we've actually had to go outside and hire an independent head now to sift through some of this information. So we have somebody on retainer, Gordon Barnhart, the former Lieutenant Governor actually of Saskatchewan, is the City of Saskatoon's head right now. So, but just once, and it's a great idea. You don't want your mayor or Reeve dealing with these issues because the requests typically come from, not always, but typically from two sources, and that's either the media or someone who's really angry with you. So you don't want the mayor or the Reeve sifting through that and having to deal with that, because it's likely their records are likely being requested in addition to everything else. So
that's good. Thank you. My second question is in regard to council minutes. Is a municipality in compliance with the Privacy Act when, say, for example, we're doing tax enforcement and the lot block and plan numbers are down as on record? Names aren't used, but are we in compliance with that Privacy Act by listing that? Because it is public record.
Yeah, actually, the city of Saskatoon publishes that in the newspaper, so that, yes,
Good.
it's
Just
fine.
want to make sure of that. Thank you.
Yeah, good questions.
My name is Pat Hume. I'm the mayor of Creelman. Candace, you might have answered this partially in your previous response, but we've recently had a case where someone asked for a copy of all of our bylaws. Now, that information, a lot of it's available on the web. Does that kind of information, if it's available elsewhere, is it subject to the Freedom of Information Act?
If the information's published anywhere, whether it's a website you maintain, a website someone else maintains, all you have to do is direct them to that publication of it.
Okay, good. Thank you.
Thank you.
Hi, Steve Haziak of Univista. I'd be interested in your opinion on what the correct process or proper thing to do if the applicant is the head.
There's an interesting case about that. If you go to the commissioner's website, you can review all of the reports. And there was a case that came up where the applicant.
That would be us.
That was you. Wow. I think the commissioner's recommendation in that case, which I don't disagree with, was that there would be a sort of a contingent delegation. That the policy that delegates the head's authority to another party should be contingent on if the person who is the acting head makes a request, it goes to someone else. Right. So even if there's no standing delegation in place, there should be a policy that says there will be deemed to be a delegation in any case where the head makes an application, him or herself.
So can that be done as a resolution then?
I would think so, yeah. It seems to me it's the same thing that Tiffany addressed with having a policy in place that delegates it. Saying that it's only delegated for the purposes of the head making the application is just a limitation on that delegation. So I don't see any reason you couldn't do it as a policy.
Okay. And just quickly, we record our council meetings, but a resolution has been made that recording is specifically for the administrator in assisting her in doing the minutes. Is that recording covered?
My opinion off the top of my head is that it's probably disclosable. If someone were to make a specific request for it, you would be forced to provide it.
Hi, I'm Nicole Molchat. I'm the administrator for the villages of Ram and Buchanan. First of all, what I'd like an opinion, what we do, we're two small communities, when it comes to rental utilities, we do not give out water or sewer accounts unless the landlord is on the account with the tenant. So is that acceptable from a privacy standpoint? Because for other reasons in the Act, we do not give water and sewer accounts to tenants unless the landlord is also on the account. So would that cover off our privacy concerns of notifying the landlords?
I think it does.
Okay. Then, I know that won't work for bigger ones, but it does
It's
work
a great
for us.
idea. I like that approach.
Okay. Then secondly, when a person, a resident or an employee comes in and requests to see their file, can they demand to see the originals, or are we within our rights to only give them a photocopy of their file?
One moment.
Because in a situation where somebody might demand to see their original file and then damage some of the records or refuse to return some of the records.
Okay. I've actually never come across that issue before, so this is a learning process for me. But Section 10 of the Act covers this off. And it basically says the head may give access by providing a copy of the record. If that's not practical, then you have to give them an opportunity to examine the record itself.
Okay, so, but as long as we can
if it's all
photocopy it?
reflected in the photocopy you're giving them, you are not required to give them access to the original.
Okay, great. And then I have, sorry, my other question just walked right out of my head. So thank you very much.
Thank you.
I'm Dennis Doughton, the mayor of Christopher Lake. And the question I have for you, I noticed you had up there accuser and the accused in a correspondence. So what I'd like to know, we had something like this come up in one of our meetings. The accuser or the accused stated that he had the right to face the accuser. Is that right or incorrect or correct?
Well, I think that's invoking a whole bunch of other questions that aren't specifically within privacy law. I think you're going into employment law, and the sort of harassment issues are beyond the scope of this. Just in terms of the written harassment investigation report, any personal information of the other party would be redacted, but any conclusions that come out of the report would be shareable. But I think what you're asking goes sort of beyond those specific freedom of information requests and into something entirely different, which I'd be happy to discuss with you at another time, but I don't know that it's appropriate today.
Okay.
Thank you.
Thank you.
I'm just going to add one small note, and Candace is entirely correct, but that particular question is a hotbed of discussion, I'll let you know. And I'll give you, again, an example in Saskatoon is, before we had an independent head, we used one of our members of our administration to sift through these requests. And the reason why we had to go to an independent person is because it suddenly pitted the administration against the mayor and council in yet another way. With these FOI requests, because suddenly we had the city clerk going through councillors and the mayor's email accounts and pulling out information and sending it out. And it was a very awkward situation. But when we had it in-house, our clerk at the time took the position that, because we would always say, well, who's fine, we have to give it out, we'll comply with the legislation, but who's asking for the information? And our clerk at that point in time took the position that we weren't entitled to know that, and I think the former privacy commissioner also agreed with that. Since we've now transferred it independently, our city solicitor takes an opposite view now that our administration, now we're all back on one team. And we have an independent person, and she tells us who asks for that information. I'm not entirely confident that the privacy commissioner agrees with that decision, but we now know, again, we are 100% compliant with the legislation, but you know, we like to know who wants to rifle through my email account, and so she tells us. So that is an ongoing debate. I'll just let you know, and so it's an issue that all of you might want to tread quite carefully on. The City of Saskatoon may be willing to engage in an expensive legal battle on that, but some of you may not be. So just tread carefully would be my only advice with respect to that.
Yeah, good afternoon. Greg Ross, Northern Village of Pinehouse. Now that we find ourselves caught in the midst of these sort of discussions and as a community, since 1988 I've been part of either mayor or on council with the community, and we find ourselves now with the first request coming to us. What are the chances that a lay person is going to mess up if they respond to this? That freedom of information versus your right to privacy and all the different, again, if you don't mind, you're right, it seems overwhelming. What are the chances that you need to have somebody who knows what they're doing to deal with this?
I think it's very difficult for any municipality, and particularly a small municipality, to deal with these requests properly. I mean, you don't have dedicated staff, you don't have a lot of training on this. I think it is extremely difficult to deal with these properly. And I know in relation to Pine House, the commissioners issued that report, which was quite unfavorable, but in his postscript said basically it is not realistic to expect a small municipality to be able to handle these requests on their own, and actually suggested the creation of an independent provincial organization that would assist municipalities in dealing with these. So I think even the commissioner or the former commissioner himself has recognized that it is extremely difficult for a municipality to be able to deal with these properly without making some error.
Right. Now in turn, in answering that way though, but the court of law, which is again now kind of where we're getting to, the court of law doesn't need to be as sympathetic. They still have to follow certain. So again, not so much an answer, I guess, maybe more of a heads up that these sort of rounds are becoming more of the society that we live in, and I'm not even going to suggest the budget or the dollars that's going to come out of our operation just to try and deal with this. So it's a dilemma. I'm not sure what all, I've got 100 questions to ask you, but the most important one is small communities, the expertise is needed, a request one every 25 years. There's just some unrealistic activities that can happen to a mayor and council.
Yeah, I think your observation is absolutely on point. There's so many technicalities in this legislation. Just take, for example, the line that has to be in there about requesting a review within a year. Unless you're familiar with the Act, that's one of the last things that you would even consider, right? You're trying to balance those issues of making appropriate disclosure and maintaining confidentiality. Your mind doesn't go to the little things like making sure that they know they have a request for review. And so I think it's very, very difficult, and I think the Commissioner has recognized this, to comply with all of the things that you need to comply with in that Act.
Good. All right, thank you.
Thank you.
So we have time for one more question. I'll just let...
My name is Kelly. I'm with the town of Fort Qu'Appelle. I was just wondering, I guess we do get a lot of requests for information through our office, and we don't, I guess, normally go through this for the application process. Is it something that should be done diligently for every request? Is that important? Will it fall back to that?
I think it is important. It's difficult sometimes depending on the volume of requests that you're getting. But I do think at least as far as the Act is concerned and as far as the Privacy Commissioner's office is likely to be concerned, your response has to be the same on every single one of them, which is to start from a presumption of disclosure, work backwards, look through the exemptions you have, and then issue a response which fits within the Act. And I don't think there's any deviation from that.
Okay, thank you.
Thank you.
So that brings our session almost to a close. I'm just going to provide one more piece of information. There was a question earlier about when somebody asked what happens when the information comes in and it's the head. And Candace talked about limiting, if you delegate to a head, you can limit what they do. And it sort of caused me to remember that not that everybody has to follow the example of what Saskatoon does, but I just merely offer this as some practical advice for all of you, is that when Saskatoon designated its head, it's actually only related, we also limited that to requests coming in about the mayor and council. The routine administrative FOIs that we receive about minutes and those things, our administration handles in the appropriate fashion. But when it comes in about the mayor and the councillors and issues that we have shipped that out to an independent authority just to keep everything clean and a little easier. So you don't have to, from an expense perspective, because of course you have to pay this person, if you were trying to manage this from a budget perspective, one small suggestion might be to take the sort of the hotbed issues and farm those ones out, and typically that's dealing with the elected folks, or possibly you may take certain issues like land transactions or something like that and send that out and manage the rest in-house. So that brings us to the end of our session. I really appreciate everybody coming and the interesting questions. If you can please join me in thanking Candace for her great presentation. Thank you. No, I was like, oh, wait a minute. Couldn't do this, but
Hi, I'm just wondering, do you have this on the website, or the SUMA website? Last year nice to finally meet you in person.
yes.
I don't know if they know I can email.
Hi.
All right.
Nice to see you. Oh, well, thank you. Nice to see you. Hi, Erhard. How are you?
Good to see you. Yeah, thought I'd say hello.
I'm glad you did. Oh, thank you. Good. I'll see you around.
This would have helped less where you know, and I can get
Thanks. Oh, thank you.
Okay. Does it have to be on what I have and if I have right on right now?